tell them that you couldn't talk about it?
Yes.
Did they stop?
They did.
Okay. Is there anything that they said that influenced you in any way?
Possibly, but I tried not to let it.
All right. We'll talk to you about that a little bit later in private. Okay. She's Jurors 205. She was in seat 22. She was in seat 22, panel 1. Her juror number is 205. Okay. I can't hear a word you are saying. You're going to have to use your original charts.
Is the court going to identify each juror?
Yes,
For the
when I'm
record?
talking to them, I am.
Okay.
Okay. All right. Anyone else who got any information at all? No? All right, thank you. Deputy, I'm sorry, but you're right in my line of sight of the jury. Thank you. All right. This is phase 2. As I explained to you, we're going to do this in 2 phases. I'm going to give you some preliminary instructions, and then I'm going to send you into the jury room. We're going to bring you out for individual instruction. All right? Some of what we're going to be talking to you about is anything you know about the case, your feelings about the death penalty, and your feelings about a defense that is being raised in this case. All right? There's a couple of things you need to remember throughout these proceedings. And this is the first one and the most important one you need to remember. Jurors must be able to presume that Mr. Loyd is not guilty. He's innocent of the charges until and if the state of Florida, these 2 gentlemen, can prove beyond a reasonable doubt that he is guilty of the charges. Mr. Loyd is charged by indictment. And let me tell you that an indictment is just a piece of paper, this is it right here, that tells someone what they're being charged with. You have to tell people what you're charging them with. This is how the state of Florida does it. You cannot use the fact that someone was indicted or charged with something as evidence that they're guilty of it. That's not how our system works. But he's been charged by indictment with first-degree murder with a firearm of a law enforcement officer, attempted first-degree murder with a firearm of a law enforcement officer, aggravated assault with a deadly weapon, carjacking with a firearm, and possession of a firearm by a convicted felon. The first charge, the first-degree murder, if convicted, carries with it the potential for a death penalty sentence. All right? And I'll explain to you how that works. There are 2 phases to this trial if you're a juror. Phase 1 is what we call the guilt phase. And during that phase, your job is to determine, based solely on the evidence you hear in this courtroom, whether or not the state has proven beyond a reasonable doubt that Mr. Loyd is guilty of one or all of these charges or not guilty of one or all of them. That's your job in the first phase. What might happen if he's convicted is nothing for you to worry about. You have to focus solely on guilt in the first phase, all right? The guilt phase is pretty much conducted the same way we do all criminal cases. You'll be asked to return a verdict of guilty or not guilty on all counts. Your verdict must be unanimous on all counts, meaning that each juror must agree on each count either to acquit or convict. But as I previously said, only murder in the first degree qualifies for the death penalty. The burden of proof for the government is the same in the guilt phase of a capital case, which is a death penalty case, as it is for every other type of criminal case. It is proof beyond a reasonable doubt, and the instructions you will receive on reasonable doubt will be identical to the one given in all other criminal cases. The burden on the state is not higher because of the possible penalty. When you are deciding guilt in phase 1 of the case, you will be instructed to ignore the possible sentence during this phase. In other words, we ask jurors to decide whether a defendant is guilty or not on the charges, including murder 1, on its own merit, and you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty of murder in the first degree, as well as any other offenses charged, or guilty of a lesser included offense, or not guilty. And we expect you, of course, as a juror, to carefully consider the facts before you reach a decision. The fact that a defendant might face a death penalty is to play no part at that stage in the proceedings. If and only if the jury returns a verdict of murder in the first degree, the jury will reconvene for the purpose of rendering a verdict as to which sentence, death, or life imprisonment without the possibility of parole should be returned. If that happens, a special set of rules and instructions come into play. I'm going to give you an overview of it now. The actual instructions in both guilt and penalty phase are typewritten and given to you. They're very specific. I'm just giving you an overview right now, folks, all right? Because the death penalty in Florida is reserved for one class of crimes only, and that is murder in the first degree, the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty, so they've created a list of circumstances which jurors are to consider in reaching a verdict in a death penalty case. Some of these the prosecution finds helpful, some of these the defendant finds helpful. The ones the prosecutor may rely upon are called aggravating factors. The state is required to prove these factors beyond and to the exclusion of a reasonable doubt, and they are limited by statute. The ones the defendant relies upon are called mitigating circumstances. Mitigating circumstances do not need to be proved beyond a reasonable doubt. A mitigating circumstance need only be proven by the greater weight of the evidence. Mitigating circumstances are not limited by statute and may include matters relevant to the defendant's background or character or circumstances surrounding the offense, and they will be offered as a basis for a verdict of a sentence of life in prison without the possibility of parole. Before you may vote, the court impose a sentence of death. The state must prove beyond a reasonable doubt one or more of the aggravating factors that they have alleged. The process of considering the aggravating factors and mitigating circumstances to determine the proper punishment is not a mechanical or mathematical process. The law contemplates that different factors may be given different weight or values by different jurors. In your decision-making process, you and you alone are to decide what weight is to be given to a particular factor. Regardless of your findings in this respect, however, you are never compelled nor required to vote for a sentence of death. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. It has to be a unanimous verdict from the jury. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If, after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility for parole. Again, this is just a broad outline of how this works. Detailed instructions are given at every step of the case. Let me say this too. Right? Let me caution you that the fact that I'm talking about the death penalty is not to be taken by you as any indication one way or another as to whether or not this is a case which justifies a death penalty. I don't know that, and you don't know that. I'm only discussing it because it's a possibility. It doesn't presuppose anything. We just have to be ready in case it happens for you to understand how you have to proceed here. We're going to be asking you some questions about this procedure. We're going to be asking you some questions about all the things we talked about, and the lawyers are going to do that in some detail. Some questions are going to be on the death penalty. I want to prepare you so you can be thinking about it. In general, they're typical questions. They may or may not come your way, but I expect they probably will. You're going to be asked whether you have any moral, religious, or personal feelings about sitting in judgment of a defendant's conduct in this case. We will ask about your feelings about the death penalty, and if you're in favor of the death penalty, whether or not you agree with the premise that a sentence of death is not appropriate for all first-degree murder cases. You may be asked whether you would agree to weigh the aggravating factors and mitigating circumstances with an open mind and determine whether death or life imprisonment without the possibility of parole would be an appropriate sentence. You may be asked whether you are opposed to the death penalty such that you would not consider it a penalty under any circumstances. Many people have strong feelings about the death penalty, both for and against it. The fact that you may have such feelings does not disqualify you to serve as a juror, as long as you can put those feelings aside and apply the law as I instruct you. In other words, you must be willing to be bound by your oath as a juror to obey the laws of this state in delivering your verdict. Questions may be asked about whether your opinion concerning the death penalty would substantially impair your ability to follow the court's instructions. You're also going to be asked questions about a defense known as the insanity defense. Mr. Loyd has raised a defense of not guilty by reason of insanity. I'll talk to you about that in a little bit more detail individually, but that's something that you have to be able to keep an open mind as to everything that's being presented to you in a courtroom, including any defense that a defendant may raise, such as not guilty by reason of insanity. I'm going to read to you a short statement about this case. Folks, this is just a short statement. It is not evidence, all right? On the morning of January 9th, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019 and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. Based solely, number one, on the facts that I just read to you, or the statement I just read to you, and anything that you may personally know without telling me anything other than, without just raising your hand, how many of you have heard about this case? All right, so I have the juror in seat number 2. You're juror 339, is that correct? All right. Who else? Raise your hand. So juror in seat number 3, you're juror 204? Okay. 5. So you're going to be juror seat, you're 32? You're number what? 20? Okay. Who else heard about it? Okay, the last two. Ma'am, what's your juror number? 283? No, 293. 293. And your juror 205. Okay. Of the ones that just raised your hand, have any of you formed an opinion? Again, all I want to know is just raise your hand. Have any of you formed an opinion based on what you've heard already as to Mr. Loyd's guilt or innocence? Juror in seat 2, juror number 205. Anybody else? All right. Okay, I'm going to send you back into the jury room except for you, juror in seat 205. Why don't you stay here with us, or juror number 205. We're going to talk to you about what's going on today. Yes. The rest of you go into the jury room. Do not talk about this case among yourselves. We need to give her a microphone, please. Okay, thanks. Guys, they sent the signature, I thought, but never mind. We'll work on it. We'll figure it out, yeah. All right, ma'am. For the record, your juror number is 205. You were in seat 1. I'm sorry, you were in the first panel in seat 22.
Correct.
Okay. Tell me what you think you know about this case.
Well, I just know kind of the general overview of the alleged shooting of a police officer, but that's about it. I don't know like a lot of the details, but I do what my coworkers were talking about, and I asked them to stop.
All right, tell me what they were talking about.
Well, they were just talking about how, this trial was about to happen, and their beliefs on the case, like how if like a police officer is involved, that it's, it's really serious. And I mean, any murder is serious, but like specifically with a police officer. And they were also saying what they thought, that he like was allegedly
Right,
like
so
guilty.
based on all of that, you said you formed an opinion about guilt or innocence?
About what? Sorry.
Whether he's guilty or innocent?
Yes, I would say it is hard for me to keep an open mind. So I would say that I would lean more towards guilty.
So at this point, you're leaning towards guilty?
Yes, ma'am.
During the trial, if you were placed on the jury and the witnesses were being called, would you be sitting there thinking that Mr. Loyd has to convince you that he's not guilty?
Has convinced me that he's not guilty?
Yeah.
I mean, possibly. I'm not really sure.
You're not sure? Okay.
Yes, ma'am.
Thank you, ma'am. State, any questions on that issue?
No, Your Honor.
Defense, any questions on that issue? May I excuse this juror?
You may. No
All right.
objection.
Ma'am, thank you very much. The court appreciates your service. You are free to go. You're excused as a juror. You're going out that door. Go down to the jury room. They're going to give you the letters that you need for your employers or school or whatever. All right? Thank you. Let's bring in the juror who was in juror number 207. He was in seat number 1, panel 1. No, I'm sorry. Not him. Sorry. Bring in juror 339. You know what? Yeah, he was in seat number 3. Bring me 339 in seat number 3. I need to wake up. All right, sir, have a seat. Just in the middle there so everybody can see you. I know that's not anyone's fondest wish, but just, you can have a seat. All right, your juror number 339 and your original seat number was 3, is that correct?
Yes.
All right. All right, sir, you indicated you'd heard something about this case. Can you tell me what it is you heard?
I just remember seeing it on the news when it was happening.
When you say on the news, on television,
Yeah.
internet, where do you?
On the television, yeah.
All right. How much of it did you see on the news?
Not very much.
You see one or two stories, 15
Just-
stories? What'd you see?
Like one story maybe. When we were here last time, I didn't really know who he was until I remembered what I saw on the news. That was pretty much it.
Okay. So prior to hearing it on the news, had you ever heard of the case?
No.
No? All right. Did you form an opinion? Well, tell me what you heard. Let's start with that.
Basically everything that you had recited. I'd heard that part on the news, but I didn't know about the first trial or anything.
Okay. Since that time, have you heard any, and that was the morning that you were coming to jury
Yes.
selection? All right. And since that time, have you heard anything else about the case?
No.
Or read anything?
No.
Anybody tried to talk to you?
No.
Did you form an opinion about whether Mr. Loyd is guilty or not? Remember, this case is solely about Lieutenant Clayton. Have you formed any kind of an opinion about that case?
No.
As I told you, jurors have to approach this with an open mind. You have to presume he's innocent. That's the law. You have to start the trial saying, this guy's innocent until and if the state can prove to me he's guilty. Do you believe you can do that?
Yes.
Can you set aside anything you may have heard on the news?
Yes.
All right. Tell me about your thoughts on the death penalty, please.
I think it's circumstantial, depending on the crime.
Okay. Are you opposed to the death penalty, in favor of the death penalty, anything like that?
Neutral. Yeah.
Neutral? All right. If Mr. Loyd was found guilty of first-degree murder and the jury was asked to determine life or death, or vote life or death, life in Florida is without the possibility of parole, meaning you die in prison. Right? The death penalty, the state has to prove one or more aggravators beyond a reasonable doubt. Defense gets to put on mitigation. Mitigation is reasons they believe life is the appropriate sentence. The aggravators are reasons the state believes death is the appropriate sentence. You then go back in the jury room with your fellow jurors, and although you all discuss this as a group, and you go through the aggravators, the mitigators, you go through your process of determining whether or not you believe life or death is the appropriate sentence, it's an individual decision. To impose death, it has to be, for the court to be able to impose death, it has to be 12-0. It has to be unanimous. But even one juror can say life without the possibility of parole, and then it's a life sentence. You understand that? Do you think you could go through that process with an open mind? Do you think you could listen to, even though you had convicted Mr. Loyd, do you think you could listen to both the state and the defense and treat the sentencing separate from your verdict and the guilt and just determine what sentence you believe would be the appropriate one? Is there anything that's causing you any hesitation about that? All right. In this case, Mr. Loyd has raised the defense of insanity. There's a specific jury instruction on this, but in essence, it has to be, the defense has to raise it, prove it by clear and convincing evidence that either Mr. Loyd did not know the consequences of what he was doing at that time, or that he knew what he was doing, but he didn't know it was wrong. That's a very short version of the rule for insanity. There's a specific jury instruction. Like everything else, you have to be able, as a juror, to sit there and listen. You can't start the trial out going, yeah, I'm not buying that. You have to listen to everything that's presented and then make a decision one way or another about that. Do you think you could do that?
Yes.
Is there anything about the defense of insanity that makes you uncomfortable, that makes you think, I'm not going to be able to do this?
No.
All right. Thank you very much, sir. State, you may inquire.
Good morning.
Good morning.
So tell me, if you wouldn't mind, what it is that you're thinking as the judge is explaining to you that this is a case where the death penalty might be an option. So in other words, I heard you say that you're neutral on the idea of the death penalty, but I'm asking about your thoughts on participating in a very real way in that process. Could you tell me what you're thinking?
It is a little bit.
A little what? I'm sorry?
It's a little bit daunting.
Right.
But if it's something that I have to do, I'll do it.
Okay. Have you ever served on a jury before?
No.
So from nothing all the way to the very top end at
Yeah.
the beginning. Okay. Have you ever had an opportunity to think about the death penalty or have a conversation with anybody close to you? It's kind of one of those you have. Okay.
Yeah.
Can you tell me about that conversation or what your thoughts were on it?
Like I told the judge, I think it's circumstantial based on the crime.
So I take that to mean that you can imagine some scenarios where the death penalty, in your view, might be appropriate.
Yes.
Could you tell me one of those scenarios? In other words, were you talking about a case with somebody, a specific case with somebody, or have you thought, if this crime were committed, that person deserves to die? Has there been a thought like that?
Yeah.
Can you tell me about that, please?
I think discussing like serial killers and things like that.
Right, serial killers, okay. Any other ones that you can think of?
No.
So I'll give you another example that has nothing to do with this case. You heard the judge talk about aggravating factors, right? And we have to prove at least one aggravating factor beyond a reasonable doubt. You heard that?
Yes.
So one of the aggravating factors, the victim was a child under the age of 12. Some people say that if a child is involved and it's the murder of a child, then the death penalty should be automatic. Are there any situations factually that for you think the death penalty should be an automatic punishment, or in your mind, that's just always going to be the appropriate punishment?
No, I think I would need to learn everything first.
Okay. So no matter what, you'd want to make a specific determination. Is
Yeah.
that fair? Now, you've obviously heard on multiple occasions already this morning that it is alleged that a law enforcement officer was killed. Does the involvement of a law enforcement officer specifically make you lean towards the death penalty or away from it in any way?
No.
Okay. Fair enough. The judge gave you an overview of the process, and that overview took 6 minutes to describe. It's a lengthy process if we get to that point, because remember, the death penalty is only appropriate if the defendant is convicted of first degree. Anything about what was described to you that you think would make it difficult for you to participate in this process?
No.
Obviously, you said that you recognize the weight of it, right? So my last question on this topic, because we've had sort of a hypothetical conversation now, but let's say you're selected as a member of a jury and that you go through the process and yet you find with your other 11 jurors that at least one aggravator has been proven beyond a reasonable doubt, and that after listening to any mitigation that is presented, that you believe the aggravating factors outweigh the mitigating circumstances, and that you personally believe that under the law, death is the appropriate sentence. You with me?
Yes.
Could you, not in a hypothetical sense, but if that were the circumstance for you, raise your hand in the jury room and say, yes, I vote to impose a sentence, or that a sentence of death should be imposed upon a defendant, another human being?
Yes.
Come on up here. All right. You may answer the question, sir. If you don't remember it, the state will repeat it for you.
Could you just briefly say it again?
Sure. What I was asking is, if you find under the law, as the judge describes it to you and the facts that are presented, that you believe that the death penalty is appropriate, could you raise your hand and vote to impose a sentence of death on another human being if that's what you found to be the appropriate sentence?
If that's what I believe was presented as evidence and everything, yes, I
Right.
could leave my feelings out.
Conversely,
I would leave my feelings out.
Conversely, if you believed that an aggravator wasn't proven beyond a reasonable doubt, or that based upon what you heard, that death was not appropriate, could you also stand up and say, death is not appropriate, I do not agree, and vote for life in prison without the possibility of parole?
Yes.
Okay, thank you, sir. So I have a couple of questions about the concept of insanity, all right, and then I'm going to be finished. And because of the nature of that defense, I'm going to ask what may be perceived as some more personal questions, so forgive me. Have you personally or anyone close to you dealt with what I'm going to call significant mental illness in any way? Something that impacted a person's daily life?
Yes.
Okay. Can you tell me who that person, not like their names, but who they are to you and sort of describe the nature of what you heard or what you've dealt with?
Just myself personally, I had a diagnosed panic disorder where I would have like anxiety attacks for hours on end, and it impacted my daily life until I had therapy and everything.
Okay. So you've gone to get medical.
Is it showing up on your, sir, can you try and, I know those masks are really hard. Can you try and, it may
Better?
be better if you hold the mic lower.
No, that's not better.
That's not going to work either. Just try and speak up. Thanks.
So you were explaining to me, I think, that you've actually sought treatment successfully for your illness. Okay. So I would think that you recognize that mental illness is a real thing. Right? You can appreciate why I'm asking that because there are some people who don't see it that way. You agree? Okay. Any friends or loved ones deal with that issue? Did I hear you say have you been prescribed medication for that or? Okay. Anything about that medication make you groggy or tired or forgetful in any way? Okay. And how long have you been dealing with this issue, sir? Okay. And obviously you work and have managed to go about your day, right? Okay. Do you think anything about your personal experience with that topic would make it difficult for you to be fair and impartial, and more specifically, fair and impartially weigh the allegation or claim that a person has a mental illness? No. Do you think it would give you any special insight on that topic?
In this circumstance,
Probably not. Obviously, it's very different than what you dealt with. Do you believe that even assuming that a person has a mental illness, that it automatically absolves them of any conduct that they engage in? No. It sounds like to me, and if I'm wrong, correct me, that it's sort of for you is like the death penalty issue, it depends on the circumstances?
yes.
Okay, fair enough. So, one general question before I sit down. Is there anything, as one of the lawyers trying this case, that you think, life, background, or experience, that we should know about you, given that we're trying to find the most fair and impartial jury we can in this situation? So let me give you an example, okay? You had a loved one convicted of murder, or you had a loved one who was the victim of a serious crime and that impacted you. Anything like that that comes to your mind, and if there is something, it will come to your mind, that you think we should know about in your past or background?
No.
Okay. If selected, I'm assuming you're willing to serve even though that this is in a difficult and unique circumstance?
Yes, I am.
Okay. All right. Thank you, Your Honor.
Thank you, Mr. Rowley.
Thank you, sir.
Mr. Lemon, you may inquire.
How are you doing today, sir? So, do you think the fact that you had mental health treatment in your life is going to make you more of a skeptic than someone who has an open mind?
No.
Okay. How long have you been receiving treatment?
Probably 3 years total.
Okay. And during that time, you talked openly with your close friends and family about it?
Yes.
So you don't try to keep it to yourself? Okay. Now, the issue involving insanity involves a number of different things that have to be proven. There has to be a mental illness or defect, and there's another standard, the second standard. But one of the things the judge is going to read you is that it is the judge who decides if a person is found not guilty by reason of insanity, where to send that person. Okay? In this particular case, Mr. Loyd has been sentenced to life in prison already. He's never getting out of prison. Would that make it easier for you to find him not guilty by reason of insanity? Okay. All the things that Mr. Williams talked to you, now that you know that my client is a convicted felon who's serving life, how does that play into your thought process and internal prejudice, things like that?
Like the judge said, it has nothing to do with this case, so I wouldn't think about it.
Okay. So you're able to put it aside?
Yes.
Now, you had said you only watched one news story. Is that right?
Yes.
Do you watch the news?
Not really, no.
So you're not a news person? Don't read the paper? Don't follow it? Do you remember where you were when you actually remember hearing about this? How long ago it was? Okay, so you haven't heard anything since? Okay. Now, you had said that in a situation where a person is convicted of first-degree murder, it's premeditated, there's no question, there's no defense, that you would never vote automatically for death. Why?
Can you speak up a little bit, sir?
Sorry. I just think it would be a bias if I formed an opinion without hearing any evidence.
Okay. Now, there's going to be a set of rules that we're going to talk about in a little bit. But before I get to those rules, in regards to death penalty, on a scale, one being not against the death penalty on any situation, and 7, always voting for the death penalty, where would you find yourself?
So like I had said before, probably.
Now, when you say 3 or 4, would you lean more towards 3 or more towards 4? Okay. But the impartiality issue is really, the question is not about impartiality, it's about how you feel about the death penalty. So I think you told a little bit to the prosecutor about how you feel about the death penalty, but I'm not really following what your internal feelings are about the death penalty.
Okay. I honestly believe that, like I said, it depends on the case. I am for it if I find that the evidence and everything supports it. I am against it if I find the thing it.
So you're really talking kind of in general terms.
Okay.
And what I'm really interested in, why?
I don't know, honestly.
Is there something that drives you to that decision?
No,
Okay.
give a feeling on something that I don't know yet, if that makes sense.
Sure. So I'm going to ask you some questions about that and get to know you a little better. Do you think that life without the possibility of parole is a sentence that you would consider? Is there anything about that, like the taxpayers are going to pay more money versus the debt penalty, anything like that? Okay. Now, in this case, like all death penalty cases, the ultimate decision you make is an individual decision. You understand that?
Yes.
This is completely up to you. And although you can talk about it with other jurors, if we get to that part of the case, it's your decision. Now, sometimes in that situation, there's someone who ends up being kind of bullyish in the jury room because they have one opinion or another. Strong death, strong life. Would you be able to put those opinions aside and not be influenced by them?
Yes.
Why do you think you can do that?
Because my opinion is my own.
Would you verbally tell that person in front of the other jurors, listen, this is an individual decision. We all heard it in the court. You're going to leave me alone.
Yes.
What about if they're going after another juror, whatever their position is? Would you be able to stand up for them?
Yes.
Okay. Now, some people feel that the killing of a police officer all the time.
And
Okay? And when we're talking about kind of the rules that play out in the case, if we get there, you heard the prosecutor talk about aggravating circumstances. There are a limited number of those. They have to be proven beyond reasonable doubt. Once one is proven beyond reasonable doubt, and you move to consider the mitigation and weighing that mitigation, as the judge talked about. It's a different standard, lower standard than what the aggravators are. And then you have to weigh the mitigators against the aggravators. Now, some people don't like and can't accept some types of mitigation. Now, I think it'd be a little foolish to ask you about mental health, because you clearly would consider mental health. That wouldn't be a problem, right? What about someone who has dealt with racism their entire life? Would that be something you're able to consider?
Objection.
Let me see the attorneys at the back. And I have one right here. You may proceed.
I think we were talking about the ability to consider.
Mr. Lenneman, I can't hear you. Do you have your mic on?
I think we were talking about generally your ability to consider things as a mitigating factor. And generally, would you be able to consider racism as a mitigating factor?
Yes, I would.
Okay. What about something like brain damage?
Yes.
Okay. Would you be able to consider generally trauma that a person suffers?
Yes.
Now, we were talking about this individual decision-making of yours in this part of the case. And the judge had talked about, if we're coming down the line, where there's a checklist where you go from, the aggravator being proved beyond a reasonable doubt, mitigation being proven, you weighing the aggravating factors versus the mitigating factors. The legislator has clearly empowered our community that even if you feel that the aggravators outweigh the mitigators, you never have to vote for death. Do you understand that?
Yes.
No matter what anybody tells you. It's your decision. Some people call that mercy, some people call that whatever. It's whatever you believe it is, but you have the entitlement. You understand that?
Yes.
Now, the legislator also wanted to, when they created the statute, they wanted to offer to the jury and to the community the importance of an individual. And it's called victim impact. That's exactly what it's called, victim impact testimony. So people will come into a trial and they will testify about the relationships and that person and what that person brought back to the community. Now, a lot of times it's very powerful evidence, very emotional evidence. But the legislator understood and knew that you could not use that as an aggravating factor. You can't use it in any way to consider death. But you can't consider it as a human being. Would you be able to do that?
Yes.
If I can have one moment, Judge. Now, you were talking throughout both your communication with Mr. Williams that you wanted to hear the evidence. I think the judge went through, but I just want to make sure we're on the same page. You understand technically a defendant never has to put on any evidence. It's the burden of the state to prove the case beyond a reasonable doubt.
Yes.
Okay? Insanity is different. Insanity means that the defense would have a burden they have to prove in order to prevail on that. Okay?
Yes.
You understand that?
Yes.
All right. Sir, do you understand that the death penalty will only come in play, as the judge said, if there's a conviction for first-degree murder.
Yes.
Thank you.
All right, thanks, sir. I don't believe we have any other questions for you. Hold on one second. Anything from state?
No, Your Honor.
Defense?
No.
All right, sir, first of all, let me tell you, you're free to go to the Blue Ridge vacation that you have planned for the 14th to the 18th.
Okay.
Trial's not going to start before that.
Okay.
We're going to give you the coveted purple dot, Teresa. We're going to be giving you the coveted purple dot, which means you're going into the final stage of jury selection.
Okay.
I don't know what day that's going to occur because we have to get a certain number of people through to that stage. So, do you have the slip that tells you what number to call? I was so ticked off. All right. I've got a jury sequestration package for you. There's some differences when you come back.
Okay.
right? This packet explains to you what it's like being a sequestered juror, but you're going to need to pack the night before you come here and bring your suitcases to the courthouse, leave them in your car. If you're picked for the jury, the deputies will escort you to the car and get your belongings and all that. But
Okay.
you have to arrive at the courthouse already packed in case you're picked, because we sequester the jury as soon as they're sworn in.
Okay.
All right? That packet provides quite a bit of information for you about that. We are trying to get for you, and I apologize, there's a delay from the jury room. There's still a slip of paper we're going to give you that has a phone number on it that you call. You're going to need to, don't call it before Friday.
Okay.
Or actually, don't call it before Thursday, all right? And it's going to tell you when to report back for general jury selection. You may hear purple dots, we have no information for you, meaning we still don't have a date.
Okay.
Just keep calling until we give you a date to report back. You would report back to the jury room that morning, and then they'll, pull everybody and bring them upstairs. If you can just have a seat outside the courtroom and wait for a few minutes till we get the rest of this paperwork. They tell me it's on the way up. My apologies.
Okay.
All right? Do you have any questions about what you're doing?
No.
All right. Thank you very much, sir.
Thank you.
And once again, you can keep the mask. If you get enough of them, they can be stocking stuffers. All right, let's bring in juror number 204, who was in panel 1, seat 4. Good morning, sir.
Good morning.
All right. You're juror 204, is that correct?
Correct.
And you were in seat 4 originally in the
Correct.
first panel? Okay. All right. Got a few questions for you. Let me start with, you said you'd heard something about this case. How much have you heard?
I mean, pretty much what you explained earlier, I already knew.
Okay. When you say pretty much I already knew, what did you know? Tell me before you walked into this courtroom, if I said to you, describe this case to me, what would you say?
I would say that it's about a person who killed a police officer. I knew that. I knew that they apprehended him and there was some scuffle and he lost his eye. I knew that. I knew that that I had some feelings about this case because.
What are your feelings about this case?
Well, I mean, I just feel that being that I feel as law enforcement might have roughed them up more than they could have, and being that a police officer was slain, I could understand where that would come from, but that doesn't mean that it's right.
Okay. The fact that Mr. Loyd got roughed up and lost his eye is not relevant and isn't anything that you can consider in this case. Do you think you could follow that instruction?
Yes, ma'am.
You sound reluctant.
I mean,
Look, I'm not looking for one answer or another. We really need you to tell us how you feel and what you can and can't do. Sometimes people can't sit on a certain case. That's fine.
yeah, I mean, personally, my feelings, you know, for me, you know, I think, you know, I don't know if, how I would feel, you know, knowing that I would indirectly be responsible or could be responsible for this man's demise or him sitting in prison for the rest of his life.
Okay. Let me back up a little bit more, which is, I'm going to get to that in just a second. Based on everything you've heard about the case, do you have any, are you leaning one way or the other, guilty, not guilty, starting the case?
No. I mean, my feelings towards the death penalty have nothing to do with him being guilty of his crime.
Okay. Jurors are required to presume he's innocent of the crime until and if the state can prove he's guilty.
Correct.
If we sat you in the jury box, would you start with that, saying, okay, state, prove he's guilty?
Yeah.
Okay. Is there any part of you that thinks that Mr. Loyd is guilty of anything?
No. I mean, no. I mean, I can't be influenced by what I've heard. I mean, every case has to go to trial, or everybody got their day. So I mean,
Okay.
you have to go over the evidence and all that. I understand that, so I don't.
All right, so let's talk to you about your feelings about the death penalty. In order to sit as a juror in these types of cases, you know, as I said repeatedly, no juror is required to vote for death. But if Mr. Loyd was convicted of first-degree murder, you're required to have an open mind, and if the law and your deliberations and you're listening to the mitigators and the aggravators, you listen to all of that, and at the end you say to yourself, the appropriate sentence here is death, you have to be able to vote for death. Can you do that?
I don't think so.
You don't think so?
I'm not gonna.
Okay,
I don't
that's
think
fine.
so.
That's fine. Again, I'm not looking for one answer or another. I'm looking for the truth. And whether or not, this may not be the case for you, whether or not you can do your job. So you have doubts that you could vote for death even if you thought that
yeah.
that's what should be the sentence.
Yes, due to my personal feelings, yes.
Okay. And how long have you had those personal beliefs?
I guess ever since I was a teenager and I knew about the death penalty, I started getting in trouble. I had a trouble pass.
Okay.
So ever since then, you know, I pay attention to a lot of things in the news, not just the news, but in life and how things and how people are treated, how certain, I don't know, I kind of look at everything, so.
All right. Thank you, sir. State, you have any?
No questions from the state, Judge.
Defense?
How you doing, sir?
I'm doing all right. How you doing?
So do you think that we should live in a society where a person is excluded from the complete group of peers that he deserves in the criminal justice case?
Objection, relevance.
Sustain.
I don't,
No, sir, you can't answer the question. Sorry. Go ahead.
So here's the situation. I understand what your feelings are. I understand where they come from. But do you think that you can set those feelings aside and consider, you don't have to do anything else but consider the possibility of the death penalty in any given case?
Yes.
the possibility of
You
the,
have to be able to consider it. The law says if you can't consider it, you can't be a part of this group. So you would have to be able to consider it. Can you set aside your own personal feelings and consider it as a possible sentence in this case?
no.
Okay, thank you, sir.
Mr. Lemon, any objections?
No.
All right, thank you. So the court thanks you for your candor and for your service. You're excused as a juror in this case, and you're free to go. You can keep the mask. All right, thanks. It's the juror in original seat number 4, panel 1. Give me the juror number 20, panel 1, seat 8. I'm sorry? Number 4 just got excused for cause. Oh, number 5, yeah, I haven't gotten to that one yet. I'm not going in order. All right. Good morning. You're juror number 20, correct?
Yes.
And you were in seat number 8 in the original
Yeah.
jury panel? Okay. All right, sir. You heard all the instructions I gave you. But
Okay.
you also indicated that you have heard something about this case?
Yeah, not much information. I like you mentioned in your statement, it was the year that it happened, that it involved a police officer, and the name of the person committing the crime. But
Right.
that's it. That's all the information I know about.
When did you hear that?
Probably like last week sometime when
Last
I was
week?
Yeah, I was on Facebook. I was just scrolling through, and since I follow Fox 35, that was like one of the articles that popped up, but I didn't read it. It just kind of, that's what popped up as like the title. And
Okay. Were you here in 2017, here in Orlando?
yes.
Okay. Did you hear anything then?
No.
So between
Not that I recall.
then and last week, right before you got called in for this case, the first time you heard or read anything was on Facebook.
Yeah.
Did you ever hear anybody talking about the case?
No.
So aside from what you just told me, do you believe you know anything else about this case? Other than what I told you
I mean, you told me more information than I knew.
what I told you this morning.
Yeah,
right?
and I don't watch the news. So that kind of limits my,
No need to apologize? All right.
yeah.
I do want to emphasize to you that we're not looking for particular answers this morning. We just need you to tell us the truth.
Okay.
How you actually feel about things. All right. Well, so based on what you've heard, have you formed any opinion about whether or not Mr. Loyd is guilty?
It would all be based upon the evidence. I mean, it's a jury, so you have to, in terms of having an unbiased opinion, but obviously if I was researching and reading articles and so forth, I would form an opinion, but due to the lack of information I have and evidence, I'm pretty neutral on the subject.
And you know you're under court order not to research or form an opinion.
Yeah.
All right. Okay.
Yeah, you made
I
that
just wanted
clear.
to clear that, clarify that.
Yeah.
All right.
I'm just saying on normal circumstances.
Right.
Yeah.
So, as you sit here today, can you presume Mr. Loyd to be innocent?
I would say that I'm neutral on the subject, and innocent until proven guilty
Okay.
based on the evidence.
You
yeah.
realize that he's innocent until and if the
Yes.
state can prove he's guilty? Okay, is that a yes?
Yes,
Okay,
yes.
all right. So tell me about your feelings or beliefs about the death penalty, please.
I don't have a problem one way or another. I guess based upon the evidence that's provided, I would say some people might deserve it more than others based upon the crime that is committed,
Okay.
or the severity of it. But it's kind of catch-22 either way of what you decide, because one could argue it's an easy way out versus rotting away in a jail cell if you want to put it in that terms. So I'm pretty neutral either way on I'm not opposed to it. No religious problems or anything. So I guess it would be based upon evidence.
All right. Are there any cases that you think automatically deserve a death penalty?
I don't know. I would have to, not that off the top of my head, I would have to kind of, get a situation.
Specifically, do you believe that the death of a law enforcement officer automatically warrants a death penalty?
Well, I would say some people might be upset, but I would say the law enforcement officer, in my opinion, warrants it more than, say, a normal citizen's life.
Okay.
In that case.
All right. The law says that if, let's say Mr. Loyd was convicted of first-degree murder, and it is a law enforcement officer, you have to be able, during penalty phase, you have to have an open mind about this. You can't start with a, predisposition for life or predisposition for, you can't, you got to start in the middle, neutral. All right? You start with life, you work to death, all right? I'm correcting it. You start with life, and then you weigh the aggravators, you hear the aggravators. They have to be proven beyond a reasonable doubt. Then you go back into the jury room with your fellow jurors, all right, and talk about the aggravators and the mitigators. Aggravators are statutory reasons the state believes death is an appropriate sentence. Mitigators are reasons the defense believes that life is the appropriate sentence.
Okay.
You have to have an open mind as to both, all right? And you talk about this with your fellow jurors. Sure. All right, sir. Penalty phase.
Yes.
State's going to present aggravators, defense going to present mitigators. You have to be open to both of them, all right? You're going to go back in the jury room. You're going to talk about it as a group. You're going to discuss it all, weigh it out. And at the end, each one of you has to vote individually, life or death. But you have to have an open mind as to both. Do you believe you could do that?
I believe I could do that. I wouldn't say that I'm, hardcore yes on this specific subject.
Okay.
Yeah.
And your decision is an individual decision. Each juror, even if 11 people voted one way and you wanted to vote the other way, you can do that. You understand that? Is that a yes?
Yes.
You understand that the vote for death has to be unanimous. All 12 jurors have to agree
Okay.
before a court could impose a death sentence.
I understand.
And you understand that even if one juror votes life without the possibility of parole, meaning Mr. Loyd dies in prison, it's a life sentence.
Okay.
And are you comfortable with that?
Yeah.
Do you believe you could follow the law as to this?
I could follow that, yes.
Mr. Loyd has raised the defense of insanity in this case, not guilty by reason of insanity. The specific instruction will be given to you at the end if you're on the jury, but generally, the burden's on the defense. This is the one time, the burden's on the defense by clear and convincing to raise the defense. And the two things, they have to prove by clear and convincing, there's a mental infirmity, disease, or defect. Mr. Loyd suffers from that. And because of that, he did not know what he was doing or the consequences, or although he knew what he was doing and its consequences, he did not know it was wrong.
Okay.
All right. Like everything else, you have to have an open mind. You have to be willing to listen to the evidence and consider this and weigh it. And listen to the evidence, consider this, and decide whether you can decide yes or no, but you have to be open to it. Do you have an issue with the defense of insanity?
I don't have an issue if that was something to be presented.
All right. Do you think you could listen to the evidence with an open mind and reach a verdict on that issue?
I would believe so.
All right.
If, depending on, the evidence that was provided.
Is there anything about this case that's causing you concern that you could be a fair and impartial juror
I don't believe
to
so.
both sides?
I don't believe so.
All right. State, you may inquire.
Good morning, sir. Sorry, we're all over the
No,
court.
you're all right.
Just popping up wherever. On a scale of 1 to 10, 1 being you'd like to run out of the room screaming, and 10, it's really important to you that you be a member of the jury. Would you like to be a member of the jury?
Sorry, I slipped my brain. What was 10 and what was 1?
10 is you really want to be on the jury, and number 1 is you want to run out screaming because this is the worst thing you could possibly imagine.
No, I mean, everyone has, different priorities in life going on, so I wouldn't say it's an absolute 10, but I would say it's probably like around an 8 or something. It's important. This is actually my first time, so I'm actually interested in the process of it.
Okay.
And to help out as much as possible.
And that's what I was going to ask, but I think maybe you answered it. Why are you interested in being on the jury? Why do you want to be on the jury?
Well, I guess that kind of answers it in a little bit, yeah.
You want to help out, you're interested in the process.
Mm-hmm.
Is that a yes?
Yes, okay. Because it's my first time as well. I like to be educated in, I guess, different areas.
Your first time as a juror, is that what you were referring to?
Yes.
Like even coming up to the initial part, you've never had that happen?
Yeah, I haven't done that before.
Okay. So just to reiterate, don't presume that because we're talking about the death penalty that will even ever be a conversation. The only time that even becomes an issue is if the defendant is convicted of first-degree murder. You understand that?
I understand.
So the way the process would play out is if there's a conviction of first-degree murder, the state would have the opportunity to present evidence of what are called aggravating factors. And those are things that are just like they sound. They are facts or circumstances that make a first-degree murder above and beyond worse than your normal first-degree murder, if there is such a thing, right? And one of them that does not apply in this case, but is an example, is the victim was a child under the age of 12, right? So you can imagine why killing a child in the eyes of the legislature or the law might be worse, correct? Does that make sense?
Correct, yeah.
All right. So in order for a death sentence to be lawful, the jury has to find unanimously that at least one aggravating factor was proven beyond a reasonable doubt. At that point, the defense would have the opportunity, if they wish, to present evidence of mitigating circumstances. And those are things just like reasons why they believe that a sentence of death is not appropriate. And that could be anything about the life, character, or background of the defendant that is proven. Does that make sense?
Yes.
So at the end of, or in the middle of this process, you all will be asked to weigh, the jurors, the aggravating factors against the mitigating circumstances. And there is no specific weight. You don't tally up the numbers on one side and put them against the other. You decide as a juror, your fellow jurors decide as individuals what weight to give the aggravators and the mitigators. Make sense?
Yes.
Right? I'm explaining this because I don't want you to think that we just throw this decision, this very important decision at you and ask you to make it without some context. At the end of all that, if you unanimously find at least one aggravating factor beyond a reasonable doubt, and if there's a unanimous finding that the death penalty is warranted, only then is it authorized for that sentence to be imposed. Make sense?
Yes.
All right. No matter what you find as a juror regarding the aggravating factors, the mitigators must be considered. Now, you can know that intellectually, but my question for you is, even if you find that the aggravating factors are really severe, let's just say they personally offend you and you're angry about the crime. You with me?
Yes.
Overruled. Go ahead.
Could you still consider the mitigating circumstances before making a determination as to whether the death penalty is the appropriate sentence?
I feel like bringing emotion into it is kind of an immature aspect if you're trying to be professional and make a decision.
Right.
And I feel like you would need to consider both options and keep a level head. And as a juror, that's your responsibility.
So could you do that, though?
I believe so.
So even if the aggravators were proven, you would wait and listen to the mitigating circumstances before rendering a decision?
Yes.
Okay. Let me ask a separate question. Let's say that we go through the process and that you listen to the mitigating circumstances, and you believe the mitigating circumstances outweigh the aggravating factors, or that the aggravating factors do not outweigh the mitigating circumstances, right? Either way. In that situation, death would not be appropriate under the law. Could you reach that decision even if the circumstances made you angry?
Well, I guess we're going back to the emotion aspect of it. I'm pretty level-headed in that aspect. It doesn't, this situation hasn't really affected me any, one way or another. But depending on the evidence and how I felt of mitigating versus the other one, I would, make a decision on that, and I believe I could do so. To weigh it.
Could that decision be life without the possibility of parole if you thought it was appropriate?
If I found it was appropriate, yes.
Okay. The judge briefly talked to you or made you aware of the fact that insanity is a possible defense in this case. So forgive me for the somewhat personal nature of the question, but I think you'll appreciate why I'm asking it. Do you or someone close to you, have you gone through or experienced significant mental illness? Have you had any personal experience with that?
I wouldn't say significant. I think everyone has their spurts of depression and anxiety every once in a while with, life that's going on. But I don't have a history of that in my family nor to myself.
Any friends or loved ones or nothing like that?
Not particularly, no.
Okay. Do you believe that some people can feign or make up mental illness?
That's where it becomes difficult because if you're making a decision based upon specific evidence of one case, sometimes it can be found in previous evidence of, let's say, previous rap sheet history, because let's say they did oddball things that relate to insanity aspect or mental health related concerns, then it would connect the dots in a way.
Right.
But I feel like some people could fake it, and the evidence based upon that specific situation could show or not show that insanity aspect.
Conversely, do you believe that mental illness is real?
Yes.
Do you agree that some people suffer it and it has a real impact on their life?
I would say so. And some situations make it worse in certain times.
Is there anything about your life or history or background that you think would make it difficult for you to fairly weigh whether or not a person, number one, had a mental illness, and then number two, that mental illness led them to not know what they were doing, that it was wrong? Anything about your personal beliefs or situation you think would make it hard for you to do that?
I don't have a problem personally making a decision on that. Based upon the evidence, it would help me farther connect the dots to be able to understand, the reality of it in that situation. So it depends on, how much evidence and so forth, how strong the evidence is.
Could you imagine a circumstance where a person had a mental illness and based upon what you heard, you felt like they were insane at the time and should not be held criminally responsible.
If the
So the question is,
yeah.
could you imagine a circumstance where that's the way you would feel? That's the
Yeah,
result
I
you
would
could
say
reach?
certain mental illnesses can be improved upon. I think there's always that underlying factor that people have, but I feel like it gets to a certain point and someone could say, blow their top.
Right.
And at that moment, it could be an insanity aspect.
And you could find that if appropriate.
Yes.
Can I have a moment, Judge? I don't have any other questions. Thank you, sir. Thank you.
Thank you. Mr. Lenneman, you may inquire.
Thank you, Judge. How are you doing, sir?
Good.
What kind of work do you do?
I'm in school for my bachelor's for cybersecurity.
Okay. And are you cybersecurity?
Yes.
What's your plans to do with that?
Eventually, it's called security data analyst. They manage like the big data servers and the big warehouses. That's kind of my plan long term.
All right. Did you ever think about going into law enforcement?
More so reserves for the military,
Okay.
but due to health concerns, I wasn't able to. But never law enforcement myself.
Okay.
If anything would be close to cybersecurity, would be kind of forensics, but I've never explored that route.
And you grew up in a family that had a lot of respect for law enforcement?
I mean, we don't particularly have family members that have been
In law.
directly in the police. I mean, way back when, like 60s.
Right.
But nothing particular. I mean, I have respect for law enforcement, military, and so forth, leaders. But if that answers the question.
Yeah, thank you. Thank you very much. So, when you said, when you were talking about law enforcement, how you put them in general and public, what were you saying?
I don't know. I feel like they're kind of the, what's the word for it? They're like the securing force of the law. And so I guess they hold more value to me. And like I said, it sounds bad to some people than like a general public citizen.
Right.
But obviously, depending on the situation, you murder a bunch of citizens, let's say Pulse situation, totally different situation. It's very hard to rule one way or another. I guess just my respect is more for higher law enforcers.
So what you're kind of saying is, when it comes to like the death penalty, an officer would be higher up than everyone else, but there's a situation where if there's multiple
Or if there's children involved.
Children involved?
Yeah, it depends on the
that would
situation.
push it up more.
I guess, yeah, it depends on the situation.
Okay. So, I think the judge asked you about the issue of looking at a murder, considering the murder. And in your mind, there's a murder. It's first-degree murder. There's no defense. It's not an accident, anything like that. Do you believe that they would deserve the death penalty in that situation?
I guess it depends on my feelings and the evidence at the time. Because like I was mentioning before, putting it bluntly, it either is like rotting in prison and dying in prison, or some people would argue the death sentence may be the right thing to do, but it also could be argued as the easy way out. Some people would think rotting is kind of them suffering for their crimes that they committed.
Right.
So I guess it depends on the evidence and how I was feeling with what I discussed with my jurors and made that unanimous decision and so forth.
Okay. And so what we're talking about really is a personal feeling that you would have, that there's something that when there's a premeditated murder, that some circumstance that you would automatically vote for the death penalty?
It's difficult to say because one life, even law enforcement and so forth, is kind of hard to make that one flip or another versus, let's say it's a poll situation where it's 50 people. I would think that's like warranted in my mind right away. So it's kind of hard to make that decision, I guess, off the top of my head with just one or, two
Right.
people or something, because
Right.
it could be an insanity thing. It could be anger management problems. I don't know. It's
Right.
hard. Yeah.
Right. But you said coming out of the box, you would give the law enforcement a little bit higher.
Yeah,
than
standard
everybody
wise,
else.
I would
Okay.
say. Yeah.
In regards to the death penalty?
Correct.
Okay. Can we come sidebar, Judge?
Yeah, kind of.
Thank you very much, sir. Appreciate your time.
Sir, you also told me you were a full-time student, and this was going to affect your ability to, it might affect your ability to pay for school.
Well, that's what the work study was for that we were discussing that one time. But yeah, I'm a full-time student, but fully online.
All right. Well, I appreciate your service, I do, but I think we're going to excuse you at this time.
Okay.
So thank you very much. You're discharged as a juror, and you're free to go.
Well, thank you for your time as well. I mean, I enjoyed the process of learning this, and hopefully in the future I can become a juror.
I sincerely hope we see you again. I'm sure you'll get another chance. All right.
Thank you.
sir.
Which way do you want me to exit?
That way. The deputies are going to help you with that. In the meantime, I need juror 293 who was in seat 13. Yeah. Seat 13, panel 1. Morning, have a seat. As much as you can, with everyone staring at you, try and relax, all right? I've got some questions for you, and then I'm going to turn it over to the lawyers. Let me start with, you told us that you'd heard something about this case.
Yes, ma'am.
What have you heard? You're going to need to put that mic up
Oh,
near
sorry.
your mouth.
I mean, just on TV when it was all happening. I seen the news footage and,
Can't hear you.
okay. Just when it was on TV. Okay, I seen the news footage.
When was that?
I guess when they arrested him. I don't know when, I don't remember the
So,
date.
A couple of years ago.
Yes, ma'am.
All right. Since that time, have you watched any more news coverage about this?
No.
Or read anything?
No,
Have you talked to anybody about the case?
no,
Have you heard anybody else talking about it?
no.
All right, so your memory is from the initial arrest
Yes,
time.
ma'am.
What do you remember hearing?
Well, I remember when they had the helicopters out looking for him, and then they caught him, and then they caught him on the ground, and I guess OPD was there arresting, and that was it.
Okay. Based on is that the only, did you see one news story or several?
Oh, several, yes.
Okay. Based on what you were hearing on the news, did you form an opinion as to whether Mr. Loyd was guilty or not?
It felt to me like he was guilty.
Okay. And let me tell you, ma'am, we're not looking for one answer or another. We need people to tell us the truth
Yes.
about this to see if you can do your job as a juror. Some cases you can, some cases you can't.
Right.
All right, so would you say that coming into this courtroom, you have a feeling that Mr. Loyd is guilty?
Yes, ma'am.
The law requires jurors to start presuming Mr. Loyd is innocent. Can you do that?
Yes, with facts.
with facts? Okay.
Yes.
And by that, I mean, when you start, you can't be sitting there thinking, well, I think he's guilty, but I'll listen and see if they can prove to me he's not. Is that what you would be doing?
That's the way I feel, yes.
Okay. State? Defense? All right. Thank you, ma'am. I don't think this is the case for you, but we really appreciate your service. You're discharged. You're free to
Thank you.
go. The mask is a gift.
Okay.
All right, thanks. That was seat 13. All right. I'm going back to juror number 207 in seat 1, panel 1. Welcome back. All right, you have a seat. Relax. All right. This is, I know, an awkward situation. You've never been in it before, so try and relax as much as you can. So you've never heard anything about this case prior to what I told you this morning?
No, Your Honor.
Okay. Can you tell me what your position, if you have one, what your position is on the death penalty, please?
So what do you mean exactly?
I'm sorry?
What do you mean exactly?
Are you opposed to the death penalty, for the death penalty? Have you ever thought about it prior to today?
So this is my first time over here, so I'm a little bit nervous. I don't know, but
I can barely hear you. You've got to get that mic closer to you. Okay, thanks.
this is my first time over here. I'm a little bit nervous, but I believe like there's nothing about the law, you know. If justice got to be served, and
Okay. To sit as a juror in this type of case, we have to know that you're able to follow the law. So the law in the state of Florida is this, which is the penalty for first-degree murder is life without the possibility of parole. But in certain cases, the death penalty becomes a possible sentence. You have to sit through the guilt phase, listen to all of that, and if and only if Mr. Loyd is convicted of first-degree murder, then we go to what's called a penalty phase, where now you're going to listen to aggravators, which are legal reasons the state believes death is the appropriate sentence, and mitigators, which are reasons the defense believes life is the appropriate sentence, and life is without the possibility of parole. Mr. Loyd would die in prison. You follow me so far, okay? Both sides present their evidence. Once all that evidence is presented, I will give you the jury instructions. You and your fellow jurors go back into the jury room. And now you're looking at the aggravators, you're looking at the mitigators, you're weighing it all out. You have to make an individual decision as to whether you believe life or death is the appropriate sentence. All 12 jurors must vote for death for a court to be able to impose a death sentence. If even one juror votes for life, it's life without the possibility of parole. You got it so far?
yes,
You have to have an open mind about this, and you have to be willing to listen to both sides. Do you believe that you can do that?
yes, I do.
Is there anything about the process I just described to you that is causing you to hesitate?
No, ma'am.
Is there anything about the fact that this is the death of a police officer that would cause you to automatically want to impose death?
No.
Do you believe you could treat this the way the law requires you to treat it? Weigh the aggravators, weigh the mitigators.
Absolutely.
Mr. Loyd has raised the defense of insanity in this case. And as I indicated to you, this is not the entire insanity instruction, but I'll just give you an overview. Insanity, it's the one time the defense has to prove something. Other than that, the state has to prove everything by reasonable doubt. The defense has the burden by clear and convincing evidence to prove, one, Mr. Loyd had a mental infirmity, disease, or defect, and that because of this condition, he did not know what he was doing or the consequences, or although he knew what he was doing and the consequences, he didn't know it was wrong. That's generally what the defense of insanity is. like everything else, you have to be able to listen to the evidence about this with an open mind, with no predisposition to say, insanity, I'm never going to accept that defense, or I'm always going to accept that defense. Open mind where the evidence leads you. Can you do that?
Yes, ma'am.
Do you have any doubts whatsoever about that?
No, so
All right.
far.
Is there anything that would stop you from, at this moment, that you feel would stop you from being a fair and impartial juror in this case?
No, ma'am.
All right, thank you, sir. State, you may inquire.
Good morning, sir. Over here. How are you?
Pretty good, thank you.
Have you ever been a juror before?
No, ma'am. No, sir. This is my first time.
Okay. So, do you watch the news at all?
No.
Not at all. Do you watch any crime scene television shows or anything like that?
Sometimes.
Okay. So the judge was asking you some questions about the death penalty, and you indicated that, I believe, I'm taking it you're basically neutral on the topic. Would you agree with that statement?
Yes.
Okay. So my question is, have you ever seen on TV or heard about in the media or talked about with a friend a case or situation where you thought the death penalty was appropriate? Let me give you an example. And this is an extreme example. The Pulse nightclub shooting. Did you live here in Orlando when that happened?
No.
You did not. Are you familiar with that situation?
Yes, I heard something about that.
Right. So obviously it was sort of a hate crime, the murder of many, many individuals, approximately 50. Any situation like that where you thought to yourself, yeah, that would be appropriate in that situation?
Probably, yeah.
Okay. What circumstances have you thought about when you thought that that was appropriate? If you could just, and there's no right or wrong answer. We're just asking for your opinion, that's all.
So there's like a lot of sick persons out there, you know,
Right.
and I mean nobody deserves like who live or who dead, who's gonna be dead, you know. Nobody got that right. So I mean, I believe in second chances, but sometimes I don't know.
It depends on the circumstance?
Yeah, it depends.
Okay. But I take it from your question that in your mind there are first-degree murders where a death sentence would be appropriate.
Yes, absolutely.
Overrule. Go ahead.
Conversely, may I proceed, John? I'm sorry.
Yes, you may.
Conversely, I take it from your comments that you do not believe the death penalty is appropriate for every first-degree murder. Or do I have that wrong?
I mean, it's complicated, you know.
It is complicated,
As I
I
said,
agree.
this is my first time involved in one of these cases,
Right.
one of these scenarios. So I don't even know.
Well, let me back up and maybe describe the circumstances, the context for this, okay? The only time the death penalty is ever appropriate, ever, for any crime is first-degree murder. You understand?
Yes.
So you can't get the death penalty for sexual battery or rape or anything like that. It's only first-degree murder. All right? And there's only two punishments for first-degree murder: life in prison without parole or death. Okay? So if and only if Mr. Loyd were convicted of first-degree murder, then the jurors would have to decide which one of those two sentences was appropriate. Does that make sense?
Yes. Yes, sir.
All right. So can you imagine somebody being convicted of murder where a life sentence was appropriate rather than death? Or do you think that a person should automatically get the death penalty for every first-degree murder?
That's why we have to listen to the evidence, you know, so we have to listen to both sides.
Right. I understand. I just want to make sure that you understand that and you accept that.
Yes.
So do I understand you to be saying that you would not automatically vote to give a death sentence to everybody convicted of first-degree murder?
I believe we have to listen first,
Okay.
and so we judge.
Okay. So if Mr. Loyd were convicted of first-degree murder, we would present evidence of what are called aggravating factors. And those are things that are very much like they sound. Things about how the crime was committed, or sometimes about the nature of the victim, that make the crime above and beyond a normal, if there is such a thing, first-degree murder. So for example, something that has nothing to do with this case, but an aggravating factor under Florida law is that the victim was a child under the age of 12. Right? So most people hear that and they say, yeah, that makes sense, because if you kill a kid, then that's an aggravating factor. We have to prove at least one aggravating factor beyond a reasonable doubt in order for a death sentence to be a possibility. Does that make sense?
Yes, sir.
All right? And the jury would have to unanimously find that in order to move on to the next phase. If we presented that evidence and you made that finding, and no matter what, the defense would have an opportunity to present evidence of mitigating circumstances. And those are things about the defendant's life or background or character that they believe indicate that a life sentence rather than death is appropriate. Make sense?
Yes.
Okay? Jurors have to be willing to listen to the mitigators before making a decision on the aggravating factors. And, before making a decision as to whether death is appropriate. Does that make sense?
Yes.
It's sort of like what you've been saying. You have to listen to everything. Could you listen to the evidence of mitigating circumstances before making a final decision?
Yes, sir.
Would you promise to do that no matter what?
I do.
Okay. And then, after listening to all the evidence, the jurors will weigh the aggravating factors against the mitigating circumstances. And if the aggravating factors outweigh the mitigating circumstances, then you can determine whether or not you believe as an individual that death is the appropriate sentence. So, if you listen to all that and listen to the law as the judge instructs you, you believe personally that death was an appropriate punishment, could you raise your hand and vote for a sentence of death?
Yes, sir.
Conversely, if we didn't prove it, or if you found that the mitigating circumstances were significant, could you vote for life in prison without the possibility?
Could be.
Could be. Okay. Do you think you're leaning one way or the other?
No, let's just finish the question. Have a seat. Okay, go ahead.
Are you leaning one way or the other as to either sentence as you sit here right now? In other words, do you think, not having heard anything, do you think that death is more appropriate for first-degree murder than life in prison?
In this case?
Well, you don't know anything about this case. So generally.
Well, like I said, I have to listen both sides, then we judge. So
Okay.
I can't really tell you like what's gonna be like more appropriate, but that's why.
Well, so I'll try to ask it a little bit differently. Do you think that if you heard that a person was guilty of first-degree murder, that they should be more likely to get death than a life sentence without parole? In your opinion?
So it's my opinion. So, it's complicated, like as I said. So I have to get more involved. So
Okay.
no, what should be better?
Okay. Are you willing to go through this process and listen to the evidence and make your decision based only on the evidence in the case?
Yes.
Okay. Thank you, sir.
Welcome.
I want to ask you about insanity a little bit. So forgive the personal nature of my question, but do you believe that, have you had any personal experience with significant mental illness? And by that I mean either you or someone close to you has had a significant mental illness.
No, sir.
No. Do you believe that mental illness is real
Yes, I do.
and that people suffer from it?
Yes.
Okay. Do you believe that mental illness should automatically excuse someone from being responsible for their actions?
I don't know.
No.
I don't know.
So I take it to mean that there are circumstances where even you would find that even if there were a mental illness, that person could be held responsible,
Yes.
right? However, if it were proven to you that a person had a mental illness and that they didn't know what they were doing was wrong, in other words, that it met the prongs of insanity under the law, could you find a person guilty, not guilty by reason of insanity?
I don't know.
You're not sure? Okay, talk to me
I'm
about
not
that.
sure, I'm not sure.
Talk to me about that. Why could you find one and not the other?
I mean, it's not because I got like a mental illness. I gotta go around like killing people, like that's. I mean, like I said, sometimes you have to judge.
Right.
Sometimes.
Do you think that there's ever a circumstance where you could be persuaded that a person should be not guilty by reason of insanity?
Yes, why not?
You think there is a circumstance where you could do
Yes.
that? Right. So if it were proven to you that a person had a mental illness and that because of that mental illness they didn't know what they were doing or that it was wrong, could you find them not guilty by reason of insanity?
Could be.
Okay. It's possible for you.
It's gonna be possible.
Okay. Can I have a moment, Judge? That's all I have, sir. Thank you very much. Thank you, Your Honor.
Thank you.
Mr. Letterman, you may inquire. Go ahead and inquire, then we'll do the sidebar. I'm listening.
Good afternoon. How are you doing today, sir?
Pretty good, sir. Thank you.
What kind of work do you do?
I work for Public Distribution Center.
Okay. What do you do there?
This is like a warehouse, big warehouse. I just driving. I forklift driving.
Okay. Now, the prosecutor spent a lot of time talking about the death penalty, and I'm going to talk some more about that too. But when he was talking to you about insanity, you had indicated at first you could not ever vote for insanity, and then later on you said you could, and I'm not understanding what that means.
Well, that means like I'm nervous. It's the first time in being involved, so sometimes like I don't want to be like scared of my answer. At the same time, just trying to look for the right answer. That's probably what happened.
Now, when you say look for the
Mr.
right
Letterman,
answer,
let me intervene here for a moment. Sir, I understand that you're nervous. I want you to understand there are no right or wrong answers that you can give us. You just need to tell us what you actually believe and think, okay?
Okay.
So put aside being nervous and just be honest. All right? Go ahead, Mr. Letterman.
okay. So what is your honest thought about insanity as a defense?
You need to turn your mic on, Mr. Letterman, because I can't hear you.
It is on, Judge.
Is it?
Yeah.
Go ahead.
Hello?
All right. Go ahead.
I mean, what do you mean exactly? What?
Okay. So one of the defenses in Florida allows a defendant to raise an affirmative defense, meaning that we have to prove that he was insane at the time of the killing, in this case, the killing. And so there are some people who don't believe in that, they don't like it, they don't want to have anything to do with it, and some people will accept it and follow the law. Where are you?
I just following the law. If we're gonna get proof that guy was insane, he should be judged.
Okay. Now, in this particular case, as you heard from the judge, my client has already been convicted and sentenced to life in prison on another murder case. How do you think that's going to affect your ability to listen to the evidence when you know that?
So, well, I don't know exactly, so I have to listen both sides. Answer or my judge.
Right, but what I'm asking you, listen closely to what I'm asking you, okay? I want your opinion, not listen closely to both sides. I want to know what you're feeling. Do you think the fact that my client has been convicted of first-degree murder, do you think that's going to influence you to lean more towards them, the prosecutors, than Mr. Loyd?
No, sir.
Why?
Because I got my personal opinion, you know.
Okay.
So I got based on that, I'm gonna keep my Dutch. That's why.
What is your personal opinion? You say you have a personal opinion.
Well, not right now, but I mean, like, if I just know about the case better, I mean, like, I don't know.
Let me ask you about your language. Where are you from?
I'm from Cuba.
Okay. And how long have you been in this country?
10 years, sir.
Okay. Do you ever feel like you have a difficult time communicating with people?
Yes.
Okay. And in this particular case, there's going to be 11 other people who are going to be jurors, and you're the 12th. So you have a right, like everyone else, to voice your opinion. Are you going to be concerned about the ability to voice your opinion because of the problem you believe you have communicating?
No, that was before, not right now, but no.
When you say it was before, what do you mean?
So when I first came here to this country.
Okay. Now, there was some conversation about the death penalty, and I was kind of confused by some of the answers you were given, okay? I don't want to hear about, oh, I'm going to listen to the evidence, I'm going to listen to the evidence. I want to hear what your personal belief is, okay? If you have problems understanding the question, just ask me to say it again, okay?
Okay.
We good with that? Okay. So my first question is, if someone is guilty, you know for a fact they're guilty of premeditated murder. They thought about it before. It wasn't an accident. It wasn't a mistake. It's clearly premeditated murder. Do you think that person deserves the death penalty all the time?
Yes, sir.
Okay. Thank you, sir.
All.
All right, let me see the attorneys inside more. Oh, were you done? I'm sorry, Mr. Ron. You said thank you, so I assumed you were done.
Yes, I'm done, Judge.
Let me see the attorneys inside.
Now, this case involves the killing of a police officer. If you have any feelings about that,
Yes, sir.
can you tell me what they are?
I mean, that's really like a bad thing. And so we're supposed to judge that actions, because those not like the right actions.
Okay, but do you think that if you were comparing the regular person who was murdered versus the police officer who was murdered, that this would bother you more and concern you more?
No, sir. The same thing. It's a human being.
So, now I want to talk to you about the death penalty. Okay? Do you think that the sentence of life without the possibility of parole, as opposed to the death penalty, is a sentence that you could consider?
Could be.
Do you think that life without the possibility of parole versus the death sentence is a lesser sentence? Do you have trouble with that sentence?
No.
Okay. when you think about the death penalty, and if you're on a scale of 1 to 10, 10 being that you're really, really for the death penalty, 1 is you're really against the death penalty, where would you fall on that scale?
6.
6. So you lean more towards the death penalty.
Could be.
Why?
Oh, this is a kill somebody?
No.
So that's why.
So you already factored in the fact that he already killed somebody and what your opinion is in regards to death penalty.
Yes, sir.
Okay. Judge, can I come sidebar?
Yeah.
Sir.
Mr. Lanham, turn your mic on, please.
The fact that you know that Mr. Loyd is convicted of first-degree murder, would that affect your decision in the first part of the case, the guilt and innocence?
No.
Why not?
Because, I mean, I'm sure about what I think.
Sir, I can't hear you. I'm sorry.
I'm pretty sure about what I'm thinking.
What are you thinking?
It's like, this is not his first killing case. So what makes you think he's not going to do it again?
Okay, so here's my question. Maybe I'm not understanding you. In terms of your feelings about the fact that he was convicted of first-degree murder, as you sit in the jury and listen to the evidence and then ultimately go and make a decision about him, that's going to factor in to your decision that he was convicted of first.
No.
So what are you saying? He did it before. Why are you saying that?
Well, I mean, I'm just asking you. I don't know exactly. You know, I'm just asking you because I mean, like I said, I believe in second chances, but guy's not like doing this the first time.
Right.
You know, he probably is gonna do it again.
Okay.
And
so when you're listening to the evidence, is that something you're going to be thinking about?
I just want to listen to the evidence. That's it.
But are you going to be thinking about that he was convicted of first-degree murder?
Yes, I do.
Okay. Now I want to talk to you about the death penalty. The death penalty is only in play if Mr. Loyd is convicted of first-degree murder. You understand that?
Yes.
You won't have to decide anything before that. You understand?
Yes.
Now, it's an individual decision. You're the one who makes the individual decision. Would you be able to, if you had an opinion, whether it's life or death, maintain that in the face of other people telling you you're wrong?
Yes.
No matter what?
Yes.
Okay. And would you allow other people to be bullied by jurors who are trying to get them to change their mind in the penalty phase?
No.
Would you protect them?
Yes.
Okay. Now, I heard you talk about mental health. You said that, I thought you said that that's something you can consider as a mitigating factor.
Yes, I did.
What about race? Could you consider that as a mitigating factor?
I mean, I'm not judging people because of their race.
No. If something in his life affected him, and we prove it to you, would you be able to consider that race as a mitigating factor? Some people can, some people can.
I'm not so sure.
Okay. What about trauma, if he suffered trauma?
It could be part of the mental illnesses, right?
Okay, so you can consider that.
Could be.
Okay. And what about brain damage?
the same thing. Could be.
Okay. Those are all the questions I have, Judge.
Right.
Come sidebar.
All right, sir. We're going to have you come back for the third day of jury selection. We're giving you a packet that includes the instructions for jurors if they're chosen as jurors, because that would be the day that we would pick the jury.
I know you said that.
And it's called the sequestration packet. It's got a lot of information for you. The other thing it has is this. You need to pack a suitcase before you come the third time, because if you're picked as a juror, you're being sequestered that day. Leave it in your car. Don't bring it into the courthouse, but pack, all right? They're also giving you a number for you to start calling starting Thursday. They'll tell you when we know what day it is you're supposed to come back, because at the moment we don't know, okay?
Hey, excuse me, Your Honor. I got a situation right now. Friday, after my first day coming over here, HR called me.
Who called you?
HR from my
Yes.
my job, and they said they're only gonna pay for 3 days instead of
Okay.
the 3
Can you
weeks.
afford to miss the rest of the 3 weeks of pay?
I'm sorry.
Can you afford to miss another 3 weeks of pay after that? Would you be able to pay your bills?
No.
Any objections from state? Any objections from defense? All right, thank you, sir. You're free to go. All right, I think we have one juror left in the room. Is that correct? It should be the juror in seat number 9. There's 2. Who? All right, bring in seat 5. Yes. No, I'm telling them that. Okay. But the slip, you gave them the slip with the phone number on it, right? Okay. Yep. Thanks. Juror in seat number 5, juror number 32 is being called in. Have a seat, ma'am.
Yeah, thank you.
All right. Good morning.
Good morning.
Take a breath. Try to relax. I know this is a little awkward. Let me start by telling you, we're not looking for any particular answers from you. All right, there are no right or wrong answers to these questions. We're looking for you to be honest with us and tell us what you actually think and feel, okay?
Mm-hmm. Yeah.
You haven't heard anything about the case, is that correct?
No, I haven't.
So tell me what your beliefs are about the death penalty.
I honestly, I'm not a very decisive person, so...
I'm sorry, you're going to need to speak up a little bit.
I'm not a super decisive person, so I honestly, I've never had to be in any kind of situation where I had to really think about that.
Okay.
So I really don't have an opinion whether,
So you
it
haven't
should be
heard
an
any
option.
opinions.
Huh?
Prior to coming into this courtroom, you hadn't really thought about it much?
No, not really.
Okay, and have you hadn't formed any opinions? Is that what you're telling me?
Yes.
Okay, so let me go over this with you. Jurors in this case, ma'am, we may never get to this point, but we have to ask you about it in case we get to this point, all right? If Mr. Loyd is convicted of first-degree murder, then we go to what's called a penalty phase. And at that penalty phase, the state's going to present to you aggravators, which are legal reasons they believe death is the appropriate sentence. The defense is going to present to you mitigation, which are reasons that they believe that life is the appropriate sentence. The sentence for first-degree murder in the state of Florida is life without the possibility of parole, but in certain cases where there are aggravators that are proved beyond a reasonable doubt, death can become a possible sentence. You follow me so far?
Yes.
Right. At the end of all that evidence that's presented, I'm going to give you all some written instructions on what you're supposed to do with this evidence, and you and your fellow jurors are going to go back in that jury room, and you're going to weigh out the mitigators and the aggravators. And as a group, you're going to reach a decision, except the decision, while it's reached as a group, is also an individual decision. The vote is individual. Each juror has to decide whether they believe life is the appropriate sentence or death is the appropriate sentence. It takes 12 jurors in order for a judge to be able to impose a death sentence. If even one juror votes life, it's life, without the possibility of parole. Mr. Loyd will die in prison. You with me so far?
Yes.
To sit as a juror in this case, you have to be open and able to consider both sentences. Okay? You can't be saying, if he's convicted of first-degree murder of a law enforcement officer, I'm automatically sentencing him to death, or I'm automatically sentencing him to life. You see what I'm saying? You have to be able to listen to the evidence, weigh it all out, and reach a decision. Can you do that?
I think the guilty versus not guilty would be something I could do, but the death sentence, I think it's one of those things that I probably would have really hard time doing that, because personally, I wouldn't want to feel responsible for somebody being killed.
It's not supposed to be easy to decide, your vote in a case like this, especially, again.
Yeah, but
So are you just telling me that you just couldn't do it?
I don't think I could do it and continue my life sort of, as is. Just because, in my position, I don't think I could even fire somebody from a job without feeling like there was bigger consequences on their life. So I think that would be very difficult.
All right, ma'am. Thank you. State, any questions?
No, Your Honor.
Defense? All right. Thank you, ma'am. We appreciate your service. You are free to go. You're discharged as a juror. You can keep the mask, but you're free to go. All right? Thank you.
Thank you, Your Honor.
And then that means I have juror in seat 9, 108. She was juror number 108. Good morning, ma'am. How are you?
I'm good. How are you?
Okay. I'm going to need you to speak up so we can hear you.
Okay.
And I'm going to need you, to the best of your ability, to relax. I know this is sort of an awkward situation, but for you, but just relax. Not looking for any specific answers from you. We're just looking for you to tell us what you honestly think and feel, okay? You haven't heard anything about this case, is that correct? Okay,
Yeah.
Remember what I told you about shaking your head?
Yeah.
You got to answer out loud.
Sorry, that is correct.
All right. So as you sit here today, do you have any preconceived notions about whether Mr. Loyd is guilty or innocent?
The information you shared before was, incredibly disturbing. But,
You understand that you have to presume he's innocent until the state, and if the state proves he's guilty beyond a reasonable doubt.
Correct.
They've got to present evidence to you, and you can follow that.
Yes.
All right, tell me what your position is on the death penalty, please.
I think that if somebody goes through this process and, they are found guilty, and that is, the result of that sentence, then, that's kind of my stance. If that's the situation, then.
So is it your belief that if someone is convicted of first-degree murder, the appropriate sentence is death?
Yes.
is there any situation in which you could see yourself voting for life?
No.
State, any questions?
No, Your Honor.
Defense? All right, thank you, ma'am. You're free to go. You're discharged as a juror. We appreciate your service.
Thank you.
You get to keep the mask. The deputies will escort you out. Thank you. All right, and now we should have no one in the jury room. Is that correct? You're moving the 1030s in there? Okay. So here's what I'm going to do, because it's 25 to 12. I'm going to bring the 1030 group in, give them all the preliminary instructions. If there's anybody that obviously has has heard everything to know about this case, I'll go ahead and ask them. I'll release the rest of them to go to lunch, and then we'll go to lunch and we'll try and catch up at some point. All right. So this panel includes Juror 6094 from Panel 1, Seat 14, from the 9 o'clock group. Did 232 show up? Did Juror 232, the guy who was going to be an hour late, did he show? All right, so this panel is actually 12 people, including Juror 6094 and 232 from the 9 o'clock group. And they were seats 14 and 15 in the 9 o'clock group. Yes, sir.
It just suggests that either during the panel conversation or maybe as a starter to the first question of the individuals, if anything's changed or they learned any additional information. In other words,
Yeah, I've made a note of that.
I
yeah.
assumed you did, but
He wasn't one of the ones that told me he wasn't going to get
No,
paid.
he
I have
wasn't.
several I have a note for.
it's no
but
one's
yeah.
fault. It's just one of those things.
We're just going to, we'll talk to him again. Yeah.
Yes, Your Honor.
I've made a note. Thank you. Ready? With their original seat numbers? Good woman. Thank you. All right. Great. Thanks. Bring them in whenever you're ready. Okay. Yes, ma'am. What can I do for you? All right. If you all will raise your right hand, we're going to re-swear you in. All right, have a seat, bud. All right, I'm sorry for the wait. My optimism about how long it's going to take us to do things is eternal, but misplaced often. All right, I notice a bunch of you don't have the clear mask on. Once you start answering questions, I'm going to let you stay with the others if you want to right now. Once you start answering questions, you're going to have to put the clear mask on. Sorry, folks. I know they're a torture chamber. So you're here for phase 2 of jury selection. Here's what I'm going to do. I'm going to read you some instructions that I have and some explanations about what we're going to be doing. And it's close to lunchtime, so then I'm going to let you go to lunch. I might talk to a couple of you, but the rest of you are going to be able to go to lunch. Again, you're not to talk to anybody during lunch or read anything. So let me start with asking this question, though. Is there anybody who either heard anything on the news, read anything, or anyone told you something about this case or talked about it in front of you? Anybody on this group, in this group? Nope. All right, juror seat number 32, you're juror 421. Yes, ma'am. 32 was your original seat number, folks. That's why we're calling it. Yes, ma'am. Don't tell me anything that you said, heard, or read, but did you hear it, read it? What happened? You saw it coming up? Hold on. We got to give you a microphone. Yeah. Sorry.
I saw the trial coming up before we had the other thing the other day.
Oh, you saw it? Oh, I'll get to that. No, I meant since you were here on Friday.
No.
Okay, thank you. All right, this is phase 2 of questioning. As I told you, this is a death penalty case, so we conduct the questioning in several phases. This is going to be individual voir dire day. We're going to be asking you individual questions about this. But before we do, let me explain to you a little bit more about this case. Let me start with this. In this case, Mr. Loyd has been charged by indictment. And folks, an indictment is a piece of paper I have it in my hand. It's just a piece of paper that tells someone this is what we're charging you with, this is what we're accusing you of doing. You have to tell people what you're accusing them of doing. This is how we do it. It's not evidence of guilt. It's not evidence of anything. It just tells you what the charges are. You are not allowed to consider the fact that someone's been indicted as evidence of guilt. Everybody with me so far? All right. In this case, he's been indicted on count 1, first-degree murder with a firearm of a law enforcement officer. Count 2, attempted first-degree murder with a firearm of a law enforcement officer. Count 3, aggravated assault with a deadly weapon. Count 4, carjacking with a firearm. And count 5, possession of firearm by a convicted felon. Again, the fact that these charges exist doesn't mean he's guilty of them. These are just the charges. In the state of Florida, the only charge that potentially qualifies for the death penalty is the first one, first-degree murder. Okay? There are 2 possible penalties for the crime of first-degree murder in the state of Florida: life without the possibility of parole or death. The automatic sentence upon conviction of first-degree murder is life without the possibility of parole. In certain cases, we call them capital cases. This is one of them. Death is the second choice. Okay. All potential death penalty cases are divided into 2 parts. The first part is known as the guilt phase, and the second is known as the penalty phase. Let me talk to you about the guilt phase. The guilt phase is pretty much conducted the same way as we do all criminal trials. You will be asked to return a verdict of guilty or not guilty on all counts, and your verdict must be unanimous on all of the counts, meaning each juror has to agree on each count either to acquit or convict. But as I previously said, only murder in the first degree qualifies for the death penalty in some cases. The burden of proof for the government is the same in the guilt phase of a capital case as it is for every other type of criminal case. It is proof beyond a reasonable doubt, and the instruction you will receive on reasonable doubt will be identical to the one given in all other criminal cases. The burden on the state is not higher because of the possible penalty. When you're deciding guilt in phase 1 of the case, you will be instructed to ignore the possible sentence during this phase. In other words, we ask jurors to decide whether a defendant is guilty or not on the charges, including murder 1, on its own merits, and you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty of murder in the first degree, as well as any other offenses charged, or guilty of a lesser included offense, or not guilty. And we expect you, of course, as a juror, to carefully consider the facts before you reach a decision. The fact that a defendant might face a death penalty is to play no part at that stage of the proceedings. If and only if the jury returns a verdict of murder in the first degree, the jury will reconvene for the purpose of rendering a verdict as to which sentence, death or life imprisonment without the possibility of parole, should be returned. If that happens, a special set of rules and instructions come into play. I'm just going to give you an overview of it now. These are not the specific rules that, jury instructions that you're given. Because the death penalty is reserved in Florida for one class of crimes only, and that is murder in the first degree, the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty, so they created a list of circumstances which juries are to consider in reaching a verdict in a death penalty case. Some of these the prosecution finds helpful, some of these the defendant finds helpful. The ones the prosecution relies upon are called aggravating factors. The state is required to prove those factors beyond and to the exclusion of a reasonable doubt, and they are limited in number by statute. The ones the defendant relies upon are called mitigating circumstances. Mitigating circumstances do not need to be proven beyond a reasonable doubt, They only need to be proved by the greater weight of the evidence. Mitigating circumstances are not limited by statute and may include matters relevant to the defendant's background or character or the circumstances surrounding the offense. And they will be offered as a basis for a verdict of a sentence of life in prison without the possibility of parole. That sentence means the defendant dies in prison. There is no parole in the state of Florida. Before you may vote the court impose a sentence of death, the state must prove beyond a reasonable doubt that one or more of the aggravating factors they're alleging exist. The process of weighing the aggravating factors and mitigating circumstances to determine the proper punishment is not a mechanical or mathematical process. The law contemplates that different factors may be given different weight or values by different jurors. In your decision-making process, you and you alone are to decide what weight is to be given to a particular factor. Regardless of your findings in this respect, however, you are never compelled nor required to vote for a sentence of death. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility of parole. Now again, this is just intended to give you a broad outline of the penalty phase rules because none of you have experience with it. As I said, I'll give you detailed instructions if you're on the jury and you get to that point. Let me say this too. The fact that I'm talking about the death penalty is not to be taken by you as any indication one way or another as to whether or not this is a case which justifies a death penalty. I don't know that and you don't know that. I'm only discussing this because it's a possibility. It doesn't presuppose anything. We have to be ready just in case it happens and you have to understand how you would be asked to proceed. We're going to be asking you some questions about this procedure and all the things we've talked about today. I'm going to tell you a couple of other things. The lawyers are going to go into that in some detail. I'll ask a few general questions. Some of the questions are going to be on the death penalty. I'm going to give you an idea of the type of questions you're going to be asked just so that you can think about it a little bit. They may or may not come their way, but I think they probably will. You're going to be asked about whether you have any moral, religious, or personal feelings about sitting in judgment of a defendant's conduct in this case. We will ask you your feelings about the death penalty, and if you're in favor of the death penalty, whether or not you agree with the premise that a sentence of death is not appropriate for all first-degree murder cases. You may be asked whether you would agree to weigh the aggravating factors and mitigating circumstances with an open mind and determine whether death or life in prison without the possibility of parole would be an appropriate sentence. And you may be asked whether you're so opposed to the death penalty that you could not consider it as a penalty under any circumstances. Many people have very strong feelings about the death penalty, both for and against it. The fact that you have such feelings does not disqualify you to serve as a juror as long as you're able to put those feelings aside and apply the law as I instruct you. In other words, you must be willing to be bound by your opinion concerning the death penalty in delivering your verdict. I'm sorry, it's getting late for me. In other words, you must be willing to be bound by your oath as a juror to obey the laws of the state in delivering your verdict. There will be questions about whether your opinions, your personal opinions concerning the death penalty would substantially impair your ability to follow my instructions. Mr. Loyd in this case has raised a defense of not guilty by reason of insanity. We're going to be asking you about that. Very generally, the defense of insanity requires the defense to prove by clear and convincing evidence that Mr. Loyd suffers from a mental infirmity, disease, or defect, and that because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. So you're going to be asked some questions about your position on that and whether you can listen to that defense with an open mind. I'm going to read you a statement about this case. This is by no means exhaustive. It's just a general statement. On the morning of January 9th, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. Now, having read that statement to you, talk to you all a little bit about this. How many of you all have heard about this case? Just raise your paddles. Okay. So let's see. 14, 15, 17, 19, 21, 27, 30, and 32. Okay, you can put your paddles down. Of those of you that raised your paddles, please don't tell me anything you've heard. Based on what you've heard, have you formed an opinion as to Mr. Loyd's guilt or innocence? So 17, 19, 30, and 32.
21 also, Judge.
And 21, I'm sorry. Anybody else? No. Okay, so here's what I'm going to do since it's 5 minutes to 12. 17, 19, 21, 30, and 32, stay here in the courtroom with me for a minute. Well, actually, you all go back into the jury room, change into your clear mask for me, please. The rest of you may go to lunch. I need you back here at 1:30. Deputies will meet you outside the courtroom and direct you. And then we'll do the individual questioning then. Don't look at anything, don't read anything, have a good lunch. Keep your clear mask because you don't want to lose those. You'll need them for when you come back from lunch. All right, thank you. So 17, 19, 21, 30, and 32 to the jury room, please. Everyone else, you're free to go to lunch. You can go out that door.
Those of you coming back, leave your paddles on your seat. The ones going into your jury room, take your paddles with you.
Sorry.
The ones that go on the left, come this way.
All right, bring in 17, please. And by that, I mean the juror in seat number 17, who is juror number 104. Hi, welcome back.
Hi.
I need you to talk into that mic so that we can hear you. And we're not looking for any specific answers from you. We just need you to tell us the truth, okay? Your juror number is 104, is that correct?
Yes,
All right. You said you've heard about this case and you formed an opinion.
correct.
What have you heard about the case?
I basically just heard what the guy done, like who he shot, and in one of my classes, like we had like a small discussion about it because I'm in a class called hospitality law, and like one of the things we had to do was like discuss like major things happening, and so like that was one of the topics.
Okay. How much news coverage of this have you watched or read?
Not much of the news.
Okay. Did you read anything in preparation for the discussion in your class?
No.
And you said you've reached an opinion on this case?
Yeah.
What is your opinion?
I think that like he should have the death penalty.
Okay. So you think he's guilty and he should be sentenced to death? Is that a yes?
Yes.
All right. Do you think the law requires you to have an open mind about this and presume he's innocent? Can you do that?
Right. Yes.
You can?
Yes.
You can presume he's innocent? Or
Yeah,
you-
if there's enough like evidence.
I'm sorry, what?
Evidence. But it would be hard.
If he can prove to you he's innocent, you'd be okay?
Correct, but it would be hard.
Okay, thank you. State?
No objection.
Defense? All right, thank you, ma'am. We're going to I don't think this is the case for you. I'm going to discharge you as a juror. We appreciate your service. The deputies will escort you out. You can keep the mask.
Okay, thank you.
Thanks. Juror in seat 19 is going to be my next one. This can't be right. Yeah, it is. I'm sorry. Juror in seat 19 is juror number 94. Good morning. Good morning.
Good morning.
All right, just to verify, you're juror number 94, is that correct?
I am juror number 94, yes.
Okay, great. Just answer the questions truthfully, man. We're not really looking for one answer or another. We just need to know what
Okay.
you actually think, all right? You indicated that you've heard about this case. How have you heard about it?
In the news, on the newspaper,
How much coverage have you seen?
back when it happened, I saw and watched a lot of it.
Okay.
I found it
And-
an interesting and intriguing case.
Okay. And after he was arrested, did you watch more of it?
A little bit, yes.
Okay. You indicated you formed an opinion as to whether he's guilty or not. Is that correct?
Yes.
And what is your opinion?
I am pretty convinced that he is guilty, that he did it.
All right. Jurors have to be able to set all that aside and start with an open mind about this. Do you think you could do this? You actually have to presume he's innocent. It's not even an open mind. You have to presume he's innocent.
I know I have to presume that he is innocent, but after what I saw and I read, that's going to be an interesting challenge.
Okay. If you can't do it, just tell me so.
I don't think I could.
Okay. Thank you. State?
No objection.
Defense? All right, ma'am, I appreciate your honesty. Your discharge, this isn't the case for you. You're discharged as a juror. We appreciate your time and your attention. All right?
You're welcome.
Have a good day. Juror in seat number 21. This is juror number 45. We're still on the first panel. Hi. All right. Just tell me the truth. Don't worry about what the answer is. I'm not looking for any particular answers, all right? You indicated that you'd heard about this case.
Yes.
Tell me what,
If it's the case that I think it is, I
it a long time ago.
All right. Do you remember what you heard?
If it's the case, I'm trying to remember, but like, if it's the case, sorry, my phone's on. I can't shut it off because I got an update and I don't know how to shut it off. My thing is, I don't know if it is. I don't know if it, like, he looks kind of different, but the one that I was thinking of was the one somebody had a patch on their eye, but I don't know if that's the same case.
Okay.
But, yeah, back then, I kind of had an opinion back then.
What's that opinion?
I just don't, like, agree with any kind of, like, a case of murder or whatever. Like, I'm kind of too kind-hearted where I kind of feel bad for people.
I'm not following who it is you're feeling bad for.
Well, like, from what I heard from the case back then, I kind of felt that he would have been guilty. From what I heard on the news, though.
All right, so you have a feeling that Mr. Loyd is guilty.
Well, I don't know by hearing everything, but what I heard on the news, I felt that back then. That's why I wanted to say that, because I don't want to try to pretend like I never thought that, because back then I thought that.
Oh, no, again, you need to tell us the truth.
Yes.
All right. In order to sit as a juror, you have to presume someone is innocent.
Okay.
Not that they have to convince you that they're innocent. You have to presume they're innocent and believe that and wait until and if the state can prove that they're guilty beyond a reasonable doubt. Do you think you can do that in this case, or would you have that lingering?
I don't think I'd have that lingering in now, years later, but at the time when I heard the case, that's where I kind of, you look at something and you're kind of like, wow, that's messed up on the whole situation that happened.
Right.
But I can block that out, but I just don't want to just pretend like I never had a feeling of that, because that's not fair to him. You know what I mean?
Correct. No, you're doing the right thing, which is by telling us. Do you have any doubt in your mind that you could sit as a juror in this case and presume him to be innocent?
Yeah, if I got the information on everything that happened. And I think I've grown up a little bit as from years ago. Kind of don't really pay too much attention to the news anymore.
Okay. State, just on this sole issue, I'm going to send her,
We don't have any motions at this time, Judge.
Do you have any questions at this time on this sole issue?
No.
Okay, let me see the attorneys at sidebar. We'll be right back.
No, Your Honor, I apologize.
I'm sorry? All right, ma'am, I'm sorry. All right, I'm going to need you to come back at 1:30 for more questioning. I appreciate your candor.
Okay,
I want
that's
you to think over the lunch hour about whether you have any doubts about your ability to sit as a juror, but we'll call you back in. In the meantime, don't talk about the case, don't read anything. You know the rules, all right?
No problem.
We'll see
Thank
you back
you.
at 1:30 outside the courtroom. The deputies will direct you at
Okay.
that time. All right, thank you. Juror in seat number 30, who's juror number 241. Hello, ma'am. How are you?
Good, how are you?
All right. I'm just going to ask you a couple of questions. Just be honest with me. Don't worry about what the answer is. I'm not looking for one answer or another. I just need you to tell the truth, okay? You indicated that you'd heard about this case. How much have you heard?
So I was in school when this
I
happened.
can't hear you. I don't know if the mic's not on or it's just not near enough to your...
I was in school when this happened, so It was talked about in most of my criminology classes, if not all of them, so I'm pretty aware.
Okay. So this actually became a topic of discussion in your classes?
Yes, ma'am.
And did you follow any of the news coverage?
Yes, ma'am.
Okay. And have you followed it since the original arrest?
No, ma'am.
But
I
you said
have not followed it since, I guess it kind of went on the wayside, and then I got called here. I haven't.
Okay. When you got your jury summons, did you follow, before you came to court, and I told you not to, did you look at any stories or anything?
No, ma'am.
Did you talk to anybody about it?
No, ma'am.
You said you'd formed an opinion as to his guilt or innocence?
Yes, ma'am.
What is your opinion?
You
need to get that mic near your mouth so we can hear you.
I think that, I guess,
I can't hear you, ma'am. I'm sorry. I know you're having trouble saying, I just need you to tell me the truth. Do you have an opinion as to whether he's guilty or not?
Yes, ma'am.
What is it?
Guilty.
You think he's guilty?
Yes, ma'am.
All right. Jurors are required to be able to presume him to be innocent at the start of the trial, and until and if the state can prove he's guilty beyond a reasonable doubt. Do you think you can do that, or would you be sitting there thinking, I think he's guilty?
I would be sitting here thinking that.
That he's guilty? Okay, thank you. State?
No objection, Your Honor.
All right, thank you, ma'am. I very much appreciate your honesty. We all do. You are excused as a juror. In this case, this isn't the case for you. Thank you for your service. Have a good day. That was juror in seat number 30, juror 241. And lastly, juror in seat 32, please. Hi.
I wanted to tell you, you look better in person than that picture that's on the screen downstairs.
Thank you very much. You talking about the picture down in the jury room?
Yeah.
That was taken many years ago, but thank you. I'll keep that in mind.
Okay.
How are you this morning, or this afternoon now?
Nervous, I guess.
Yeah, this is a little nerve-wracking for jurors. Just try and relax. Just tell me the truth. We're not really looking for one answer or the other. We just need to know the truth. You indicated that you'd heard about this case. How much have you heard?
What have I heard?
How much have you heard?
I'm a news junkie.
I forgot I turned my mic down. You're a news junkie?
Yeah.
So you've been following it?
Yeah, I didn't this weekend. We have a little house in Crescent City, and I went there and decorated for fall so I could keep myself busy.
Yeah, plus now you can't. You've been ordered not to. But prior to that, were you following it all pretty closely?
Yeah.
Have you formed an opinion as to whether Mr. Loyd is guilty or not?
I have cop friends, and Debra Clayton was a sub at Dr. Phillips High School, and I taught there.
Okay, so you knew her personally?
Correct. No, I wasn't friendly with her. Just we knew that,
All right.
It was one of our SROs.
Do you believe jurors have to be able to presume that Mr. Loyd is innocent until and if the state proves he's guilty beyond a reasonable doubt? Do you believe you can do that?
No.
All right. State?
No objection.
Defense? All right, ma'am. Thank you so much for serving and for your honesty. Your discharge as a juror, I don't think this is the case for you. Your discharge as a juror in this case, you're free to go. Have a good day. That's it for folks in the jury room, right?
That's correct, Judge.
All right, we're going to take a lunch recess until 1:30, and then we'll resume questioning the 10:30 group. By then, the 1:30 group will be here, so it's going to be a long day, folks. Court's in recess.